Good morning and welcome everyone. We are very happy to start with our good relationship with the authorities within our field. We have a long session on news and trends this morning. First we have a section with the EU IPO and the Board of Appeals. And then we have a short break and we will then follow with a section of WIPO news. This morning we will start with the EU IPO. I will not make a long presentation of our speakers because they are well known and they are also available in the app so you can see all the details. But of course we, ACTA, are very happy that we have this very good relationship with the EU IPO and we're very proud to be able to present to experienced speakers who are able to give us the very latest news and interesting trends. We will start with Deputy Director of the International Cooperation and Legal Affairs Department, better known as Dimitris Botis. And he's a long-standing friend of ACTA, and we will enjoy the benefit of his knowledge and experience later in the conference as well. Following Dimitris, we will have Dr. Joer Theophile Margellos, the President of the Boards of Appeals. And we are also very much looking forward to that. Dimitris, please, the floor is yours.
Thank you, Annette. Good morning, ladies and gentlemen. Welcome to Athens. You see that this session has been entrusted to local boys, so here we are. Here we are back from Alicante. And thanks very much to ACTA for giving us this opportunity to reach out to a wider public about a number of office initiatives that are not so visible to the individual user, but which are very important for us. So I think that Annette has selected a number of topics which she would like me to address. Annette, what would ACTA members like to know?
That is very right, because I know that we are all very interested in the developments following the regulation and the new types of trademarks. So if you could please start with the new types of trademarks. How are they doing?
Well, they're doing well. As you know, they were, as we all know, they were introduced by Article 3 of the implementing regulation that entered into force on the 1st of October 2017. We had the occasion to present in detail the legal framework concerning new types of trademarks last year and the year before. So what I plan to do today is simply give you some examples about how the filings are going and some statistics. As we recall, the previous legal framework only included 5 types of marks: word, figurative, shape, color, and sound marks. And to these, the new law has added another 5 types of trademarks: position, pattern, motion, multimedia, and holograms. Already position, pattern, and hologram and motion marks were accepted, but as subcategories of other categories beforehand. Now they are self-standing categories. But what has been added is the possibility to file those marks in a video format. So I will just show you the statistics. These are statistics from October to May. So we have in 8 months what you see on the screen. There was a degree of uncertainty as to the volumes of applications that might be expected for these new types of trademarks before the new law was enacted. And indeed, in view of this uncertainty, the office, we had even created a special task force anticipating big numbers of such trademarks, just in case. Applicants seem to take a more cautious approach. The impression we get is that they are probing the system rather than filing massively. So we can see that we have 15 pattern and 31 position marks, which is not a bad number in 8 months. Then we have 23 motion marks and 10 multimedia and only 2 hologram marks, which anyway are not so common. I will give you now some examples, mostly about motion and multimedia marks, just to see how the new media that are used for these types of trademarks work. So I will show you first, I will just remind you first how motion marks can be filed. In the new law, they are defined as trademarks consisting of or extending to a movement or a change in the position of the elements of the mark. And they may include elements such as words, pictures, etc., but cannot include sound. This is very important. I'm stressing this because actually the most common error detected so far formalities-wise is that applicants file motion marks and they call them multimedia or vice versa. This is a small formality error, but it's a nuisance both for the office and for applicants. You can of course correct it afterwards, but changing the type of mark, you will receive an objection and correct it. But it is very easy to remember that motion marks do not contain sound, whereas multimedia marks also contain sound. It's as simple as that. So I will show you an example of a very classical motion mark that has been registered by now and which contains word elements. So this is a very simple motion mark. Then we can see another type of motion mark, which is less classical, I would say. So here we go. So this mark has been filed for classes 9, communication apparatus and instrument, and 12 for vehicles, parts and fittings, and it's still under examination. If we move on to multimedia marks, by definition, multimedia marks are trademarks consisting of or extending to the combination of image and sound. And here there is one difference. We can see the example, please. Here we have, well, we didn't hear the sound, but there was also sound. It is important to remember that whereas motion marks can also be filed by using a sequence of still images, multimedia marks cannot be so filed. So for multimedia marks, we can only accept videos, and the videos must be in MP4 format and may not exceed 8,000 kilobytes per second or a maximum of 20 megabytes. You can find all this information in a decision of our executive director, decision EX 17.4, that sets out all the details about the media that can be used. So this is multimedia marks. That example was taken from our guidelines, but let's see also another multimedia trademark. Can we please play the example? So this is a multimedia mark filed for intellectual property services in class 45. So I don't know if it's a heart, a mind, or a chicken, but it certainly moves. So, it has been registered. Now, let me show you two examples of less conventional marks that we have received. Both of them are under examination, so I will not comment further. The first one is a motion mark, which has been filed for services in class 41, among other education, training, sporting and cultural events, flight, instruction, arranging of air displays, etc., etc. And then I'll also show you another which is even less conventional, which is filed for classes 9, 28, and 41. Can we play the video, please? So obviously this is an extract of a video game. It's quite explicit, so it may or may not surprise you, but this is what apparently 14-year-olds use these days to entertain themselves, and this has also been filed as a multimedia mark. It is also under examination. Before leaving the area of multimedia marks, I would like to make a comment also regarding color combinations, which is colors per se and color combinations. The reason is because we have developments in this area. So just as a reminder, the new law in relation to color combinations makes it possible for the representation to show how the colors are systematically arranged in a predetermined and uniform way. This is what the law now says. Of course, the new rules also allow applicants to file a description. So the difference with the previous regime, at least as it appears in the new law, is that now it is possible to represent color combinations in 3 ways. The first option is to file a representation that shows the systematic arrangement of the colors by using blocks or stripes of colors, where the kind of mark concerned, of course, allows for this type of abstraction. Then we have the second option, that you can show how the colors will be applied to the goods. And the third option, of course, is to combine either option by adding a description. But this option comes with a caveat that any discrepancy between the representation and the description may prove problematic if the description is inconsistent with the representation. So you must pay attention not to file descriptions that are inconsistent with the representation of the trademark, especially if this is combined with option 1. I'll show you some examples of color combinations that have been filed since October under the new regime. And in most of these cases, we had descriptions which are very, very basic, so just repeating what the mark shows, just the proportion of the colors, so nothing more than that. And of course, we have 2 very important cases before the Court of Justice in the area of color combinations or colors per se. We have the appeal in the Red Bull case, in the blue and silver case, and we also have the preliminary ruling in the Hartwell case, which deals with an equally interesting issue, namely the concept of contours and the liberty of the applicant to decide on the type of mark as he chooses. 2 very interesting questions. In the meantime, more cases are entering the pipeline, like the Steele case that you see third on the slide, which has now been filed before the General Court. In particular, the Red Bull case is very important because of a statement that the General Court made in its judgment that the reproduction of the colors may not suffice to give a systematic arrangement of the colors. So we are expecting to see if this statement will only be relevant for the facts of the case, or if it is relevant only for the old law, and much will depend on how the court will solve the case. Finally, just a very short comment. We should not forget that in the Trademarks Directive, we do not have a detailed framework for new types of trademarks, which means that the member states are not formally obliged to follow the same system as the one taken by our implementing regulation. And to prevent this risk from materializing, the EU IPO has launched a strategic project called the Support to the Transposition of the Directive. And in the context of this project, we issued a common communication together with the member states last December, which reflects the position already taken in some member states, or likely to be taken for those member states which have not legislated yet, which have not transposed the directive. And we hope that this common communication can serve as a compilation that shows users the situation in each country. So I will stop here for new types of trademarks. I know we don't have too much time, so what is the next thing?
I think we're okay with time, Dimitris. Very interesting, very efficient. Another topic I would like to hear a bit more about, and I'm sure will interest the audience, is convergence.
Convergence. As you know, convergence projects are very well ordered by numbers. So we have already 7 projects concluded, 5 in the area of trademarks and 2 in the area of designs. And what is now in the pipeline are 2 projects that we call CP8 and CP9. CP8 concerns the use of a trademark in a form differing from the one registered, a very interesting topic. We know that the court is very liberal there, and it's precisely what creates our problem. We don't know where to stop. And for that reason, we thought that a convergence project in this area would be appropriate. And CP9 has to do with 3-dimensional trademarks containing additional elements when the shape in itself is non-distinctive. So it's very similar to CP3, the one that we had with descriptive words and additional elements to descriptive words. That's also a very interesting project. Both of these projects were approved by our management board in June last year. They are now working, the working groups are continuing with their work, and we hope that by the end of the year we'll have a draft common practice, which means that sometime in the second part of 2019 we might be in a position to adopt the common communication again. And we have a very interesting project also in the area of designs, which is disclosure of designs on the internet. It is very, very interesting. It's my favorite actually, because it includes very controversial questions, such as, for instance, which are the sources of disclosure, only websites or also social media, archives, etc. The effective disclosure, what is the act of disclosure, what happens if, for instance, a website contains a password, or there is geo-blocking, or it can only be accessed if there is payment involved. Also, how you establish the relevant date and what kind of means you submit to the office. Do you have to bring printouts of the website? Is hyperlink sufficient? Can you simply use, for instance, an affidavit saying that this was shown on the internet? So many interesting questions in this as well. But I believe that the most important one is a project that again concerns the new types of trademarks. It's a sequel, let's say, to the common communication that was issued under the project of the transposition of the directive. This has the code name CP11, and it was approved last week by our management board. It is to kick off in October, and it is about working with national offices about new types of trademarks. It is divided into two work streams. The first work stream will contain formalities and absolute grounds, so how to apply the Zygman criteria to new trademark types Europe-wise, the treatment of discrepancies between, for instance, the type representation and the description of the mark, and also it will work on those absolute grounds that are more suitable for the new types of trademarks, so those absolute grounds where the application of absolute grounds may differ from the classical standards. So here, these absolute grounds are the absolute grounds from 1A to 1E of the regulation, so we'll not deal with the rest. And the second work stream is about the comparison of the signs, so how you compare moving image with moving image, etc. So we look very much forward to that project. It's going to be a heavy one, also because many member states will not have any experience when this kicks off next October. So we will see. We'll have to use the examples you saw on the screen, actually, for lack of any more material. And we hope that in a couple of years we may have a common practice. So as I said, this will start in 2018 and will go until the end of 2020.
Very interesting. And ACTA is actively participating in some of these projects already, and I can assure you we would be happy to have a seat also in the CP11. Moving on, we have another type of mark which has been introduced with the regulation, certification marks. What are those exactly?
Well, we know what certification marks are under the regulation. They do not indicate commercial origin. They indicate that the products comply with specific quality standards. And here the certification marks, as they are understood under the community, the EU system, they have two specificities. The first is that the owner of the mark, who may be a public or a private certifying entity, is precluded from using the mark for designating goods and services, so it cannot be a producer of the certified goods. And secondly, a European Union certification mark cannot distinguish goods or services by reference to their geographical origin. Here, as you will see, we have received quite a few certification marks, already 114 since last October. Only 7 of them have been published. From an examination perspective, we have seen that there are a lot of small mistakes, not big mistakes, but small mistakes when applicants draft the regulations of use. Very often there are many basic mistakes, such as, for instance, the regulations of use do not repeat which are the goods and services, or the name of the applicant, or things like that. Of course, all these things are remediable, but sometimes it's surprising for us that even the elements that are mentioned in the regulation itself are not mentioned in the regulations of use. So what we plan to do there is we are working on model templates for regulations of use that people can use in case they don't have anything much more sophisticated to draft themselves. There are 10 objections in absolute grounds raised because the mark actually tries to certify the goods by reference to their geographical origin, which is prohibited. So all in all, we are optimistic that quite soon the situation will become regular with regard to certification marks as users get used to filing things more correctly and by making our guidelines more detailed. Again, in the directive, we don't have a uniform landscape with regard to certification marks, so I just want to point out here that in some member states it is optional to have certification marks in the first place, and in the second place, in some member states, again, contrary to the regulation, there may be certification trademarks which may certify by reference to geographical origin. So just to bear this in mind, because the landscape will not be uniform, as I said.
Thank you. Then I would like to move on to something called ICE, which is popping up. What does it stand for, and what do they do?
Well, ICE. It does not mean that the office has moved back to the Ice Age. For us, ICE was, let's say, a creative way of referring to the concept of initial central examination. As you may know, like most trademark offices, we examine absolute grounds in 2 steps. First, we do a pre-screening to clear the marks that are obviously non-problematic, and then we focus on the trademarks that need to be objected to. So we used to call this pre-screening beforehand. Now we call it ICE. Why? Because there is a big difference. This is a central examination because it's done in a collaborative way. So we have 12 examiners, a task force of 12 examiners, which is rotating. So all of our examiners pass through this task force. So this task force screens the trademarks that have been filed that very day, with the purpose of clearing the ones that are good, and then they discuss all the problematic cases together. So they work by cleaning in the morning, and in the afternoon they discuss the complex cases. This has brought a different spirit of collaboration in dealing with these marks, but perhaps what we can do best here is to listen to a very short video, as they say from the horse's mouth, the truth. So if we could play the video, we can see Richard Thewlis, one of our most experienced examiners.
Well, before ICE existed, we had a system where all the absolute grounds examiners were sort of sitting in their own offices and making decisions without really connecting with their colleagues. So they were kind of isolated, and they didn't have the benefit of sort of collaborating with their colleagues. So the difficulty we had was that we didn't really have a great deal of consistency or harmonization of practice. Obviously people spoke to each other, but it wasn't sort of routinely done in that way. So we foresaw a need for people to get together in a single space and to compare notes, to compare ideas, and to actually sit down and discuss practices and to challenge each other's ideas on how we should deal with marks. This wasn't really possible under the previous system. No, I think it could be something that could be introduced elsewhere. Obviously, we have a particular sort of need for it here because of the linguistic aspect, where we're comparing linguistic viewpoints. So it's particularly useful for us in AOIPOL to do things in this way. But I've noticed some positive sort of impressions. We had the head of the Danish office was around a couple of weeks ago, and the head of the British office as well. And I've noticed that they were taking on board how we do things, both from the technical point of view as well as the collaborative point of view. And yes, they seem quite interested in it. Yeah. Well, I've been in the office for a long time, since '95. This is the first time I've really been in a proper sort of collaborative atmosphere, where I really feel that we are coming together as examiners and as Europeans to work in a way where we're really interacting. The interaction is part and parcel of the project. We have to talk, we have to discuss, but at the same time, it's when rolio, we have quite a good time as well. We have a joke every now and again, and we discuss things in a serious manner, but also sort of, it can be light-hearted sometimes as well. So the atmosphere is good. This has been an important part of it for me, to try and create a good team of people who work well together. And I think it's a success in these terms.
So these are the words from somebody that must have examined tens of thousands of trademarks. ICE scrutinizes around 625 trademarks per day. They don't clear them all. I know that some ECTA officials have visited the igloo or the ICE space. I see Ruta smiling. I don't know, perhaps it's the first time that you see how we work, but what I want to stress about ICE is four things from what you see on the screen: knowledge sharing, harmonization of practice, timeliness was greatly improved. We were surprised ourselves by the big success of this idea, and more importantly, that the error rate was brought down to 3% in absolute grounds. I will not bother you with statistics, but now we don't call it anymore initial central examination, we call it interactive collaborative examination. And as Richard said, we plan to export it. We have already started exporting it in other areas. So we have NICE for classification, that's nice, no? Then DICE for designs, I don't know who throws the dice. We have IPIs for opposition, we have RICE for registry. So I don't think we will get lice or mice, but still, we ran out of areas, perhaps we might use them as well. So,
thank you for this. Could you also please touch shortly on quality management? How do you do that?
Yes, in quality, we used to have a system whereby we had an ex-ante check of certain files, and then an ex-post, we were checking a sample for ISO purposes to see what was the error rate, and we were feeding the office's service charter and balance scorecard with the results. Now, what we are doing is that we changed all that a little bit more than a year ago. So we have the IQC and the SQAP. So I'm sorry about all these acronyms. IQC, we don't check the IQ of examiners. What we do, it's an internal quality check, as we say. So when the division, be it an opposition division or an absolute grounds examiner, takes a decision, before that decision is notified, a certain percentage of these decisions is quality checked by more senior people. So the purpose is to have this done before the decision is notified to the client, so that if there are problems, it can go back and be corrected. So because we sensed that when we were examining exposed, we were losing this opportunity to correct errors. So that was the idea behind the IQC. And then SQAP is a big novelty that we launched last year. So it stands for Stakeholders Quality Assurance Panels. And here, again, a certain number of cases is checked after they have become final, together with external users, with you, with user associations. That's a result of our new strategic plan, or current strategic plan, being user-driven. So we care, we want to see what is your perception of quality, and by checking our files together with you, we want to bring our perception of quality closer to your perception of quality, and then adjust also our internal instructions in a way that will make the final product better for both sides. So basically, for SQAP, there is a phase of audit preparation, then the audit itself takes place, and then there is an audit follow-up, which is actually the most important phase, because a report is drawn up, and then we follow up on the conclusions of that report. I already see some faces in this room that we welcome for the scope. Scope actually takes place every quarter. You can see and recognize yourselves perhaps in that picture. There are 12 user associations involved. There have been 5 sessions with opposition decisions, as I said, one every quarter. Until now, 274 opposition decisions have been audited, and the next audit will be in July this year, and it will be for the first time on absolute grounds. Last thing, if you want to become an auditor, just bear in mind that you must be a member of a user association, must be proposed by your user association, and be included in the SQAP auditors list. So please contact your user association for more information if you want to become a SQAP auditor and come to Alicante very often.
Thank you, Dimitris. And finally, knowledge circles. How do they fit in all this?
Knowledge circles are currently dealing with 2 things. The first is the aftermath of the reform. As you know, again, on the 18th of May, there was a new version of the implementing and delegated regulation issues, which aligned the numbering with a renumbered basic regulation. I know that all this is perhaps trivia for you, but for us it was a big work to change the templates again and again and again. So that was the major thing they had. We were currently doing since May. We are also doing some other things like adjusting further our IT systems. We will also issue a booklet, the old booklet that people knew from 2007 with all the new regulations. And also an important message is that this year we're not publishing guidelines in trademarks. We just published guidelines in October last year. We will only publish guidelines in designs. Actually, they were sent to user associations and ECTA last week. There is until the 18th of July for comments. And we take advantage of this time to reform the support tool that contains our guidelines. So you will get the guidelines soon in HTML format with a new search possibilities, navigation tools, cross-links to Ecuria or to our database every time a decision is mentioned, and a lot of other goodies like a new tool for consultation. So this is what I had to show you today. I hope it was interesting, and thank you very much for inviting us.
Thank you very much, Dimitris. We will then move on to Mr. Margellas, the President of the Board of Appeals.
Okay, thank you very much. Thank you very much for inviting me to this ACTA conference in my country, in my city, where I have studied and spent a significant part of my life. Now I'm in Alicante, where I'm spending a significant part of my life too. I have been asked to talk about the Boards of Appeal, to practically present the Boards of Appeal, and I'm happy that I have that opportunity and to present our working methods. In order to do this, it's I have to be familiar with, okay. It's important to understand our mission. Our mission is clearly indicated in the legislation, in the regulations. And this is the way the legislator conceived the mission of the Boards of Appeal, is to provide specialized and specific legal protection and safeguards to the EU trademarks and community design owners, parties, owners or applicants who are affected by decisions of the office. And this mission, we need to do it, to perform it through an environment which has completely changed from the inception, from the period when the Boards of Appeal started functioning and now. That means I have here just an example for you. In 1999, the boards were receiving 881 appeals. And in 2017, we have received, the number there is not a good one, 2,761 appeals. That's an exponential growth, and we had to deal with that, and how we deal with that is by revising and reconsidering your working methods. It is, just to give you an example, the General Court received per year 350 cases on trademarks and designs, and they have 48 judges. We are just 18, and we receive more than 2,700 appeals from now many years, 7, 8 years. So we needed to reflect on our working methods and see how we can do it in a different way, in order to give to the parties what they need to have, what they expect to have from us, and what also the legislator asked us to do. And this is exactly what the recitals 42 and recital 9 of the delegated regulations say. The boards have to offer an effective, efficient, and complete review of the decisions of the office. And how they need to do this? By means of a transparent, thorough, fair, and equitable procedure. This is what our mission and how we need to do it. This is in the regulation. So if you go through the regulation, if you go through all these rules, there is a double aspect of the Boards of Appeal. From the one side, it is very clear, and it is in the case law, the Boards of Appeal are not courts, are not tribunals, but on the other side, they need to follow a very strict jurisdictional rules in their functioning, which offers procedural guarantees which are similar, not say identical to court ones, concerning the right of defense, the equal treatment of the parties, the contradictory aspect of the procedure, the impartiality, independence of the members, and so on. And on the other hand, they need to offer to the user something which is not offered by the European jurisdictions, a specialized, a specific protection which matches with the specialized, specific character of the EU trademark law and the community design. So, and here I have for you some slides which show the forecast for the next year, and for this year, sorry, and so what we have received through the 4 past years. You may see that in 2014, that was a peak of appeal filed. We reached an incredible number of 3,284 appeals. So that's for a very quick introduction. So we have, as I said, reflect on our methods. It was evident that we needed to reflect and adopt another way of doing this, of implementing and performing our mission. And this is what we are calling effective dispute resolution. There is no ice, dice, rice, and these kind of things. But if you like to use the initials, this is EDR. So, but we prefer to call it effective dispute resolution, and this has 2 aspects. The one aspect is the quality management. Dimitris has already talked about quality management and what they are calling active case management. The first one has to do with our proceedings, with our organization, with the service we are offering to the parties. The second one is more specific to the cases, has to do how we are dealing with the cases, with the specific cases. So Concerning the quality management, this is some aspects of what we're doing, the main of the aspects. All our decisions are quality read. That means we are following in that the example of the General Court. In General Court, they call it revision. We call it quality reading because it's not just limited in the General Court to the linguistic aspects. We are also checking factual data of the file. Then that's something which you can avoid it in the UIPO. We have also a knowledge circle. And this knowledge circle is constantly evaluating, examining, and improving our appeal proceedings. We have a coherence and consistency project which has to do with the way we are deciding mainly on substantial issues. It is true, we have seen when you have 48 judges, some, let's say, consistencies are unavoidable, but even if you are 18 members, you need to have a look to what you are doing and be certain that what you are doing and what the messages you are giving to the users and the decisions you are taking have some consistency and they are predictable. So we have a quality group which is responsible for all our quality actions, maintaining the ISO certification, because the boards also are part of the ISO certification of the UIPO. We are doing also audits internal in the boards of appeal, with precisely the goal to constantly and permanently improving what we are doing, the service, the specialized and specific service and legal protection we are supposed to offer to the users. And then, as I said, the other part, the other aspect of our EDR approach is the active case management. Here the central person is evidently, obviously, the rapporteur of the case. And then the rapporteur has to offer to the parties different options. Here you have a list of the different options. Here is missing another one, the possible option of remittal of the case in the opposition files to the first instance for re-examination, something which the legislator recently introduced. We have started to do this with the collaboration of the first instance department of the office, and the legislature found that was a good idea and then introduced this in a specific provision. I won't insist on all this. I will directly go to one of these EDR options, the grant board decisions. I would like to stress that the grant board now in the boards has a central role in guiding the practice of the boards of appeal and playing a role on consistency and coherence and predictability of our decisional practice. And I'm very happy to say that this central role of the board has been enhanced and recognized by the new regulation because you have two innovations, let's say. One concerns the executive director, because now the executive director may address to the grant board questions on which the board may needs to take a position and render a reasoned opinion on points of law which decision and position which will ensure not only coherence within the Boards of Appeal, but within the EU IPO and even within the whole system. It can be also used in the framework of convergence project. In talking about convergence, okay, now we follow the example of the office, and I think the convergence project is something very interesting, amazing, because it contributes to the coherence of the whole system, and the whole system is not only the European system, it's also the national systems. The European system of trademarks has two pillars. One is the European one, and the other one is the national one. If we want to have that system functioning well in a coherent way, we need to pay attention to the two pillars and make them well functioning in parallel. So this is what the convergence projects are doing, and we think it's an excellent idea. And then we have a convergence project in the pipeline to be approved now by the management board and so on. It's a lot of work to do on appeal proceedings. We want to find out and converge and have best practices on appeal proceedings at the level of the EU IPO, but also the national offices, the national boards of appeal. So that's, and I think within that frame also, the fact that the executive director has that possibility to address questions on points of law and ask the Grand Boards to give reasoned opinions on that, interpreting and saying how a specific provision needs to be understood, is a very good thing, which enhances the role of the Grand Board. The other part, the other innovation, is that now this is something which is offered to you, to ECTA, to Marcus, to INTA, and all other user associations, which you don't even have before the courts in Luxembourg, the possibility to submit observations before the Grand Board in all cases. That's why the cases are published in all cases sent to the Grand Board and published in the official journal of the office, and from that moment, from the moment of publication, you have 2 months to submit observations. And you have here the list of the cases before the board, before the Grand Board, a lot of cases, and I'm very sorry to say that it's a big disappointment for me to see that there were till now no observations received from any user association. So is it really a lack of awareness? Is it really lack of interest? I don't know, but you need to be clear with yourself. If you want to contribute to the system, if you want to contribute to the predictability, the coherence of the system, you need to come in, to step in, and you need to submit observations. You need to express what you, as user associations, you think that how the system needs to work. And that, I think, it's a 5 stars, let's say it like that, opportunity for you to do it. You don't have it before the General Court. So I hope that my little talk here will serve as an awareness challenge, and to you to in the future submit observations and contribute to our work. We need that. So I have to conclude, no? Okay. I have to conclude. I have prepared some recent trends by the from the Grand Board, but in any case, I don't need to go through all this because you have here Sven Stürman tomorrow afternoon, who is going to explain some trends of the case law, including all the Grand Board case law. So it remains to me to thank you very much for your attention.
Thank you very much. think we can just use 2 minutes on questions if anyone have any questions to the two speakers, or is everyone anxious to get a break? Any questions to the speakers? There's no questions, then let's move on to the break. And oh, sorry, there is one question. Peter, please.
Thank you. My name is Peter Müller. I just want to give a reply to Theophile Margelos' urge to get involved in the grand board cases. ECTA has taken a decision many years ago not to engage in amicus curiae briefs because of neutrality. We have members who might be stricken in the case. That is right now discussed, so maybe we will get engaged. But for the time being, that was the reason why we were a little bit skeptical as it comes to that. Thank you.
Well, I strongly advise you to reconsider that decision, because one of the main roles of user association is just to express the user opinion at all levels, at quality level, at the service they are receiving, and obviously at the level of how we are applying and interpreting the regulations. And I think it's a very good thing. So please reconsider if you think it's time to do it, reconsider that decision. Thank you very much.
Thank you very much. And thank you for the attention, and let's all be back at 10:30 for the update on WIPO News. Thank you.